everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're going to be talking about the voice of children in divorce cases in the UK. To discuss this topic, I've invited Olivia Piercy. Olivia is a partner at Hunter's Law, and she specialises in family law, helping divorces coupled through the financial and the children matters of their divorce. Olivia has a particular focus on cross-border cases, and her practice includes cases relating to child abduction, child protection, and relocation. Olivia has specialist expertise in cases involving allegations of domestic abuse, including coercive and controlling behaviour and economic abuse. Welcome, Olivia. It's great to have you.
Thanks so much. It's great to be here.
So today we're talking about children and how they get involved, if at all, in the divorce process. So can we start by maybe establishing when children cases end up coming to court?
Yeah, absolutely. Well, there's lots of different situations that you might end up litigating over your children. The most common is just private law proceedings, and by that we mean proceedings that come about because parents can't agree how to share the care of their children, how much contact parents should have, in what circumstances, or other specific issues like what school a child's going to go to, whether they should have medical treatment, whether they can go on holiday or live in another country. So in those cases where people who have parental responsibility for a child can't agree on a key issue, either one of them can ask the court to make that decision, and that's how proceedings come about. There are other kinds of children proceedings that we call public law, which is when the local authority might issue proceedings because they're worried about the safety of the child in the care of their parents. And then we also have child abduction cases, which is jurisdictional disputes in relation to the children.
And so what kind of orders does the court take in terms of relation to the children?
So the court has far-reaching powers in relation to children, but we often say they have blunt instruments. So a lot of the time, a parent might want the court to do something more sophisticated than it's able to with the resources available. So a court can decide who a child's going to live with, whether they'll live with both parents, and how they divide their time, whether they live with one parent and just spend time with the other parent, and if so, in what circumstances. And as I said before, any issues relating to parental responsibility. So not day-to-day decisions, not whether the child's going to drink Coca-Cola age 3 or wait till they're 12, but the bigger decisions like education and health.
Okay, and so what does the court try and encourage in terms of the parents finding a solution ahead of the judge stepping in? Is there a process before that to help the parents find solutions?
Yeah, so before you're allowed to make an application to court in relation to your children, you have to first go to a MIAM. That's a mediation, information and assessment meeting. And there are exceptions to that. Like if your application is really urgent, then a court, you can tick the urgent box. And the court might still say, well, I think you should go back to mediation after that urgent issue is dealt with. But you can't make an application to court unless you either satisfy one of the exceptions, or you've attended a MIAM. And a MIAM is just a session where you meet with a mediator and find out about mediation and discuss whether it's appropriate for you. And the mediator can then sign your form and say, maybe mediation isn't appropriate and you need to make an application. But the whole process is set up to try and get you to agree. Judges don't want to make decisions about children in circumstances where parents can agree, and in almost every court hearing I'm in, the judge is saying, it'd be much better if you guys just agreed this, and they try to create scenarios which are conducive to that kind of agreement. So for example, at the first hearing in private law cases, or the first planned hearing, if it's not an urgent case, a CAFCASS officer will be there, and it's called a first hearing dispute resolution appointment because it's set up to try and sort it out on that day. And a CAFCASS officer will be there, they'll speak to both parents, and there's a lot of pressure on everybody just to try and resolve the issues. And it's only if a case can't be resolved because there are serious allegations in dispute, or they're just too far in their positions and the judge needs more time, more information to make a decision, that the case will then continue.
Okay. So you mentioned CAFCASS, and that was actually going to be my next question. Can you explain to us what CAFCASS does? It's a specific institution that exists in the UK. It'd be great to understand what exactly it does.
Yeah, so CAFCASS, they're essentially like social workers, but they're a body which is specifically attached to the family court, and
Yeah.
their role is to assist the family court in understanding the wishes and feelings of children, and to make welfare recommendations to the judge. So sort of doing that on the ground work that a judge can't do, because we don't bring children to court. Safe and very exceptional circumstances, but we don't bring children to court in family courts in England and Wales. So we ask CAFCASS officers to speak to the children, or to speak to the parents, or observe the children with the parents, to
Yeah.
speak to the schools, social services, the police, to gather information, and to present that information to the court. And they are meant to be neutral. So there's that benefit, and they also have child safeguarding and welfare expertise.
So do they actually speak to the children, or they gather information from people around them?
Both. So
Okay.
in every children case, the first thing that happens, you issue your application, the court lists for Hudra a first court hearing, and in the
Yeah.
interim, a CAFCASS officer will call both parents and speak to both parents, and they will gather, they'll see whether there's any records of that family with the police and social services,
Yeah.
and provide a safeguarding letter to the court. So that's not an in-depth report, it's just saying, like, are there any safeguarding issues? And by that we mean
Okay.
not just issues in dispute, but issues that the court should be concerned about in terms of the safety of the children, and that's both physical and psychological safety. So that's kind of CAFCASS's initial role. Then there's obviously a CAFCASS officer at court, and then if the court decides to direct CAFCASS to prepare a report, a more in-depth report in those proceedings, because it needs that independent evidence, or it needs somebody to speak to the children, the CAFCASS officer will then, a different CAFCASS officer will then go and prepare that report, and they will speak to the parents, and if the child is very young, they probably won't be asking the child questions, but they will probably observe the child with the parents. It depends on the scope of the report and what the judge needs. Some of them are very limited, and some of them are much more far-reaching. Sometimes they have specific recommendations that they're asked to make, and sometimes they're just much more open. Older children, their views are really important, and the older the child is, and the more mature the child is, the more weight is placed on those views. So sometimes, you know, a 6-year-old might be asked their views, but that's obviously it's obviously taken in the context of it being a very young child, and we think about how that child might have been influenced, and what you know, what level of maturity they have to know what's best for them. And sometimes it can be interesting to find out what a child thinks, but it's not determinative. It's just finding out what a child thinks, and that's an important piece of the jigsaw puzzle.
Yeah, so that was going to be my next question, actually, is, you know, how much weight does the child's opinion have? And so it sounds like what you're saying is it depends on their age, really.
Yeah, and their maturity, because children are so different. So you can have an 11-year-old who really knows what's going on and what's right for them, and their view is really, you know, should be given a lot of weight. And then you could have, you know, a 14-year-old who the court just thinks they don't know what's, you know, best for them, bearing in mind their maturity, their particular circumstances, maybe if they've been under a lot of pressure. So it's all important evidence, but it's interesting, 'cause the older children get, the more people start to say they'll vote with their feet. And the court becomes very reluctant to make orders later on about teenagers, for example, which go against what they want, because what is the point in making an order that a 15-year-old should stay with one parent when they're just going to get on the bus and go go back to the other parent they want to be with? And one of the reasons we say that is because you're not ordering the child to live with one parent, you're ordering one of the parents to make the child available, or, you know, so you're putting pressure on the parent who should be giving up the child to do that. So the court doesn't want to make orders that a parent can't comply with.
Yeah.
So if you say, you know, mother has to make a 15-year-old available for contact with their father, and the 15-year-old is just like, I'm not going, you know, that mother is then in breach. So
Yeah.
that, you know, needs to be taken with a pinch of salt, and orders are carefully constructed and thought about in those ways.
Yeah. And do the parents have to agree to the children being spoken to by CAFCASS, or is that something that's mandated?
Um, yeah, interesting. I've never had a client breach that order. I've never seen it put into an order that a parent has to make a child available, because parents do tend to comply with that. But I have had a case where a mother didn't open the door.
Whoa.
So, you know, the usual order was made, and the mother wasn't
Yeah.
opening the door, and then the mother wasn't opening the door to social services, and the mother wasn't turning up to court, and the child was inside, and that was, you know, and in, you know, in those circumstances, the court is not very responsive at first when
Yeah.
orders are being reached. It should be, but it's under-resourced and overburdened. There's a
Yeah.
long wait between court hearings. You can make an urgent application, and 2 months later, you're still waiting for a response. So that's the
Yeah.
reality of the situation we're in, just in terms of the resources. But there is a process of ramping up, and the court's orders can become increasingly draconian if a
Yeah.
parent isn't complying. So if a parent says to me, "What happens if I just don't let my child
Yeah.
be interviewed by this CAFCASS officer because I don't like her, or I don't think, you know, or, you know, my child doesn't want to be interviewed," you make your arguments to the court about whether or not it's in that particular child's best interest to be interviewed. But if a judge makes a decision that that child should be interviewed by a CAFCASS officer, or normally they just direct CAFCASS to do a report, and CAFCASS does the report in the way that they see fit. So it would either be CAFCASS then going back to the court and saying, you know, I'm unable to do as I've been directed to do because this parent won't make this child available,
Yeah.
or preparing a report saying, well, I'm really concerned about this parent who's not making the child available, and therefore my recommendations are. So
Yeah.
it's all very fluid. There isn't a kind of set formula for what will be done in any situation, because each situation is different, and each child is different,
Yeah.
each
Yeah.
judge is different. There's a really broad discretion. It's really hard to know what will happen in a lot of
Mhm.
cases.
So the judge decides based on the specific context of that divorce and that family.
Yeah. Ultimately, if parents are not cooperating with court orders, um, things will not go well for them. And
Yeah.
in the long, you know, judges do not like it when their orders are breached. And the level of concern about the parent who is not cooperating starts to increase. And this is one of the problems that arises a lot in cases where there's domestic abuse.
Mhm.
Because a lot of the time, the parent who is saying they've been a victim of domestic abuse and that their
Yeah.
child's been a victim of abuse,
Yeah.
they have a very high level of anxiety, and they're trying to protect their child.
Yeah.
But what they end up doing is then often not trusting the court process, obviously not wanting to comply with orders for contact, not, you know, um, and then they expose themselves to allegations of alienation,
Yeah.
and
Yeah.
they can start to be seen as the problem. So it's really difficult to draw the line.
Yeah, it sounds like it. And so how does CAFCAS deal with, or even the judge for that matter, how do they deal with making sure that the child isn't being, influenced and told what to say?
It's not a perfect system. There are so many children caught in really toxic conflict between parents, and CAFCASS doesn't have the resources to get to the bottom of all of these situations, and there are invariably cross allegations,
Yeah.
and often sort of mirrored allegations. So you're like, each of these parents is saying exactly the same thing, and one of them saying, you know, they're always saying both parents will often be saying the child's manipulated, and it's
Yeah.
really difficult to get to the bottom of that. You know, is this a high conflict situation where both parents are responsible for you know, welfare concerns about the child? Is this a domestic abuse situation where mirror allegations are being made? CAFCASS, you know, they are obviously highly trained social workers. They are the best people available to do this work. But it's a mixed bag. Sometimes you get an amazing CAFCASS report, and sometimes you get a really rubbish one. You just think, wow, so much weight is going to be attached to this document, and you spent like 20 minutes talking to these people and you didn't even, and then obviously as a lawyer you just believe your client. So sometimes sometimes you read reports and you think, oh, that's not helpful. We do have another option, which is sometimes parties will opt to instruct an independent social worker instead of a CAFCASS officer, because CAFCASS is obviously a very overburdened, underfunded public body. And you can say to the court, the parties can agree, or the court can direct that the parties can privately pay an independent social worker to do a report instead. And that's always my preferred option, because you can choose someone that you think is good. And they will put the time in, and it is much more expensive, obviously, but you're already in court proceedings, and these are decisions about your children, so it's affordable. And they just put in a lot more time. They speak to the school teachers, maybe meet with the parents 3 times, spend a lot of time with the children, and just do a much more in-depth report, which is often needed.
Yeah, and I guess, of course, there's also the option of having a child-centered mediation where the children can speak to the mediator and express their opinion in that context.
It's quite rare, but I have had cases where that's happened. Obviously with older children, not younger ones. But you can definitely have child inclusive mediation. I've also seen judges write letters to children or write court orders with a view to older children reading the court orders, which sometimes is really important in terms of the messaging. Because a lot of the time at the end of a court case, there'll be an anxiety about, well, who's going to tell the child what the judge has decided, and what if when there's so little trust between the parents, what if the other parent's putting a spin on that? And so sometimes just something directly from the judge to the child, or the independent social worker, but who's going to tell the child in a way that allows them to feel reassured that the right decision has been made in their best interest by somebody with authority when they've been sort of battered about in this storm between their parents.
Yeah, because I can see how that could be a concern for the children, trying to, well, first of all, being worried about what the outcome of all of this is going to be, because it impacts them directly, but also some of what they are saying to the CAFCASS officer, potentially going back to one of their parents or being made public. How confidential are those conversations?
Not confidential, and that is one of the problems that I face quite often, where my client will say, if my children make disclosures about how they feel about the other parent, it's going to get back to the other parent. They know that it causes the child huge anxiety just being involved in proceedings in that way. And then if a parent really is sort of emotionally abusive and manipulative, and lacks that insight into how they're affecting their child, they may well say inappropriate things or make the child feel guilty, or the things they say. And these proceedings are very, very slow. So a report can come out and it may then be another 2 months before there's a court hearing. And then the judge says, I've got 5 hearings in my list today. I don't have time to get to grips with this, and nothing changes. And it's there isn't much protection. And I suppose that's why I said the court only has a few blunt instruments. A lot of the time, a client wants something more sophisticated to change the other parent, really, and we can't change the child's other parent. The court can only decide how much time the children should spend and resolve individual disputes, and sometimes can direct a parent to get the support they need. So may say, I want this parent and this child to have family therapy, or I want this parent to have therapy, or I want this parent to produce clean drugs tests, or whatever it is, or to complete a domestic abuse perpetrators program or something. So the court has a few options that it can sort of deploy to try and help, but usually what a party wants is so much more sophisticated than the court does not have a legal solution to all of these family problems. And court proceedings themselves are expensive if you're represented. They're bruising, frustrating, you know, and lots of people do need to be in the court system, but if you don't need to be in the court system, then it's, you know, it's the space that you should be.
So is it better for everybody if it can be agreed among the parents? Because anyway, they're going to be making another 100 decisions and thousands of decisions over the months and the years that follow relating to their children. So they're not going to be able to go to a judge every time they need to make a decision.
Yeah, I'm of the view that where there isn't domestic abuse, where that's not a factor, where there's no safeguarding issues, parents
Yeah,
would be much better off going to mediation, maybe getting a family therapist, and
yeah,
having somebody who's got the time to help them to build a workable dialogue and
yeah,
to help them to come up with detailed agreements so that they're not fighting on a day-to-day basis about all of the different little issues. Like if you've got a plan in place which says, well, this is how we're going to split the holiday, so we don't need to argue about every single one,
yeah.
you know,
I completely agree.
even right down to like how we're going to hand the passport over so that it's
Yeah,
not like a battleground, and it's all agreed in one go. And I do have clients who go to couples therapy after they've separated in order to build a really healthy dialogue, and
yeah,
to build those tools to work effectively post their relationship.
yeah,
And I think that's so admirable and just so smart, really. And it's great to see that kind of thing happen. And more people should be going for holistic solutions and not thinking that the court's going to have the answers.
yeah,
By the same token, I think that cases where there is an ongoing dynamic of domestic abuse, those
yeah,
cases often should be in the family court, and those people shouldn't be
yeah,
pressured into mediating when that's not a safe space for them. And a
yeah,
lot of people do need court orders. You know, they need an order that is enforceable, and they need that neutral authority of the court. The problem is that there are
yeah,
so many cases in the family court that nobody's getting the service that they need. So I'd like
yeah,
to see a vast number of cases not in the family court and finding other healthier, more constructive, and more time and cost efficient methods of reaching solutions, so that the family court is then available to the cases where that is necessary to keep people safe.
yeah. No, that makes a lot of sense. This is all really helpful. Thank you so much, Olivia. It's been really insightful and very interesting. I had one last question, which is, in what proportion, in your experience, what proportion of cases involve the children being heard and consulted? Is it something that happens almost systematically, or is it quite rare, or somewhere in the middle?
Children cases,
Mhm.
like, so obviously a lot of the children are too young to be consulted.
Yeah,
So where do those questions start? Maybe around 7 years old, or you might
okay.
start asking a child what they think. But it's obviously much less weight being given to a child. I think in a case, like a relocation case, I know this is a very common part of your practice because you've got
Yeah,
such an international client base, where there's like a really key decision like that, like, do you want to move back to do you want to move to France with your mum, or do you want to stay in England with your dad?
yeah,
You know, they will start to ask children, and that starts to carry more weight after the age of 10.
mhm,
But it,
yeah,
might become a relevant question to ask at an earlier age. Um, but yeah, I think it would always be, I think there's always going to be a mechanism to ask the children wherever there is a dispute,
yeah,
and the child's views are relevant. Um, uh, yeah, I think in most cases, it's really about whether the parties can agree. If the parties can't agree, what's best for the children, and one of them saying, the children want to live with me, and the other one saying no, they want to live with me, the court's going to have to get a CAFCASS officer to go out there and ask the kids, because how else are you going to resolve it? But it
yeah.
doesn't mean that the
And
children's views would be determinative, but I think someone needs to speak to the children in that situation.
for the judge who's trying to make a decision based on the children's best interest, hearing from the children directly is going to be key in helping them inform them. So I
Yeah.
can see why.
I think that in itself can be so problematic, though, can't it? Because a child should never be made to feel responsible for their own care arrangements and for choosing
Yeah,
between their parents. And so I think often it's more where there are like safeguarding concerns.
yeah,
Because if parents are saying, oh, there's no issue with his care, there's no issue with her care, I just want the kids, for over half the time, and I just want, I have had cases where the children aren't then asked, and the judge just goes, "Well, neither of you raising any issues with the other one's care. You're just saying that you
Yeah.
want, that you think they're better with you." So they just kind of split it down the middle.
Okay.
So it's not a given that the children are always going to be asked in every situation just because they're older. It
Okay.
depends. It's kind of case by case specific. But definitely as the children get older, you wouldn't have a case. It'd be rare to have a case about a 12-year-old, but the 12-year-old wasn't spoken to.
That's helpful to know. And I think there's a lot of research that shows that actually involving the children, consulting them, not, of course, not giving them the decision power, but consulting them, feeling them, giving them the impression that they have a voice and that they're being heard and their opinions being listened to. That's all really important to them psychologically, as well as divorce isn't being done to them. They are somehow involved in their decisions around their care.
Absolutely. And I think sometimes it's not about asking them what they want, it's just asking them how they feel. And that can be really revealing. Like you
I
can
can
just ask a
imagine.
kid, like, where's your happy place?
Yeah,
How do you
you
feel when
find
you
out a
spend time
lot.
with your mum? How do you feel when you spend time with your dad? What's your favorite thing to do? What was what does your ideal home look like? And just in a
Yeah.
non-pressured way, you can get some really important insight.
That's the value of having a trained person from CAFCASS doing it rather than a judge who doesn't necessarily know how to handle those kind of
Exactly.
situations.
Yeah.
Great. Well, thank you so much, Olivia. It's been really, really helpful. I appreciate all your tips, all the information you've shared. So thank you so much. And
Thanks for
and
having
I hope
me.
we'll see you again soon.
Thank you.
Take
Really
care.
enjoyed it. Bye.
Bye.